When conducting personal data processing activities deemed necessary or related to online interaction in a limited face to face class, the following points and principles shall be observed to greatest extent possible. Let's start first with accountability. An educational institution is accountable for all the personal data it collects and processes. This obligation subsists even in the following conditions. It outsources or subcontracts its personal data processing activities, and it has properly obtained the consent of its students or their parent or legal guardian in the case of minors. Information about education is a sensitive personal information. According to the Data Privacy Act, information about education is SPI. As such, its processing is generally prohibited. It may only be processed in specific circumstances, which includes the following: when the data subject has given consent, when the processing is provided by applicable law or regulations that afford adequate data protection, when processing is necessary to protect the life or health of the data subject or another person and the data subject is unable to give consent, when processing is necessary to achieve the lawful and non commercial objectives of public organizations and their associations. However, processing must be confined only and related to the bona fide members of such organizations or associations. When processing is necessary for purposes of medical treatment. However, such treatment must be performed by a medical practitioner or a medical institution, and an adequate level of data protection is ensured. When processing involves information necessary for the protection of lawful rights and interests of natural or legal persons in court proceedings. When processing involves information necessary for the establishment, exercise, or defense of legal claims. And when the information is to be provided to government or a public authority pursuant to a constitutional or statutory mandate. So, as what the image is being shown here, this should not be posted publicly. In order for legitimate interest to be an appropriate basis for the lawful processing of personal information, the following three-part test must be met. 1. Purpose test. Does the processing have a legitimate interest or purpose? 2. Necessity test. Is the processing necessary to achieve such interest or purpose? Is there a less intrusive way to achieve the purpose? And 3. Balancing test. Is such interest or purpose not overridden by the concerned individual's rights and freedoms? The principle of legitimate purpose states that the processing of personal data must have a declared and specified purpose that is not contrary to law, morals, or public policy. Another principle of data privacy is proportionality. The processing of personal data shall be adequate, relevant, suitable, necessary, and not excessive in relation to its declared and specified purpose. Personal data shall be processed only if the purpose of the processing could not reasonably be fulfilled by other means. As what you can see in the image included in this presentation, the requirements for a person to be able to para makautang is not proportion with its purpose. As you can see, a lot of requirements is being asked by the sari-sari store owner. The principle of transparency. A data subject must be aware of the nature, purpose, and extent of the processing of his or her personal data, including the risks and safeguards involved, the identity of personal information controller, his or her rights as a data subject, and how this can be exercised. Any information and communication relating to the processing of personal data should be easy to access and understand using clear and plain language. Transparency can be demonstrated through the following: consent, privacy notice, and privacy policy.